Hello, and welcome once again to the Global Students Introduction to the Law of the United States. I am Professor Pedro A. Malavet of the Levin College of Law. Continuing our discussion of the American Constitution, today I give my second session on the growth of federal authority by discussing the Commerce Clause. As I mentioned the last time, the growth of federal power has been incremental, and I would suggest that there are two fundamental periods of growth. Last time we spoke about the period immediately after the American Civil War. Today we talk about the modern period in which the Congress has been able to use the Commerce Clause to occupy fields that were previously essentially reserved to the states. The Commerce Clause of the Constitution. The Commerce Clause allows the national government to regulate interstate commerce. And the Supreme Court has ruled that that does in fact allow the national government to regulate activities that are only within the state, meaning intrastate activity, as long as it can be found that the cumulative effect of those activities can have effect on the national economy. And so that Supreme Court ruling in 1942 was significant. It significantly expanded the authority of the national government to regulate what is now deemed to be interstate commerce, even though it was exclusively intrastate activity. The Commerce Clause has been especially significant in the promotion of civil rights in the United States. In particular, we talked last time about Plessy v. Ferguson, about the decision of the Supreme Court that ruled that states had a right to permit racial segregation and, in fact, to legally require racial segregation. We also discussed that private individuals were permitted to behave in bigoted ways, and therefore private businesses could refuse to sell to African Americans, for example. Well, the use of the Commerce Clause allowed the United States Congress to pass legislation which invalidated private discrimination. The Heart of Atlanta Motel case in 1964. The court approved of a federal law that banned racial discrimination in public accommodations, even if they were privately owned, because that had an effect in interstate commerce. Importantly, the court found that not only was this a matter of commerce, but also of an interstate right to travel, which is considered quite significant by the Supreme Court. The mobility of Americans, the ability to travel within the entire national territory, is so significant that the court said that unduly interfering with it, which racial segregation in accommodations did, was something that the Congress could invalidate by statute, and indeed the Congress did. In the Katzenbach case, the Supreme Court accepted Congress's explanation that racial discrimination in fact does affect interstate commerce, that if you are black and not able to stay at a hotel in Atlanta, it makes it difficult for you to travel there, of course. If you are not able to take on gas at a particular gas station, if you're not able to eat at a particular restaurant because of the color of your skin, that limits your mobility within the United States, and the court ruled that the Congress could invalidate acts that enforce racial segregation in that manner. Recently, however, the current Supreme Court has limited the Congress's authority under the Commerce Clause. United States versus Lopez in 1995 is a decision by the Supreme Court of the United States that limits congressional authority in exercising its legislative powers under the Commerce Clause. Specifically, the court struck down a federal criminal law that punished possession of a handgun in or near any school. The effects argument that was articulated by the United States Congress, meaning that criminals use firearms in violent crimes and that would have an economic impact on the people's right to travel because they would be discouraged from traveling to places with high crime rates, was rejected by the Supreme Court. And the court ruled that this interferes with the state's authority to regulate most criminal activity. In fact, the states have general police power to regulate criminal activity. So the fact that violent crime in or around schools could impede people from traveling, or it could limit the educational processes, which means that our citizens are less productive. All of those articulations of a national effect that were made by the Congress were rejected by the Supreme Court in United States versus Lopez. The Supreme Court, however, did indicate that there are areas that Congress may regulate under the Commerce Clause, specifically the use of the channels of interstate commerce. For example, the Congress can continue to invalidate racial discrimination in public accommodations for travel, because that does in fact affect the channels of interstate commerce, the ability to use the national road system. The instrumentalities of interstate commerce may also be regulated by the Congress. For example, the Congress may set rates that can be charged by railroads even if they're just for intrastate transportation. There can be national legislation regarding what railroads may charge because they're essential to transport. Activities with a substantial relation to interstate commerce may also be regulated by the Congress under the Commerce Clause. Labor practices of employees who have a substantial effect. This is important because the Congress can say that if you have more than a predetermined number of employees, you can be subjected to certain regulations, like, say, national health care. The other area that is also often an example of commercial activity is agricultural activity. The cumulative effect doctrine, which we have already discussed, that even though someone is raising a crop for their personal consumption in the state of Florida, the cumulative effect of small farms can add up to something that has an effect on the national economy, and therefore Congress may regulate that. However, the Supreme Court has issued some limits on congressional authority to regulate commerce. In New York versus the United States, the court invalidated a federal law that attempted to encourage states to develop a system for disposal of hazardous radioactive waste. This has been a continuing problem. There's a lot of radioactive waste that is produced in all of the states, and how to dispose of it is a major challenge. Congress attempted to develop a system by stating that if states failed to develop a plan, that they would acquire ownership of any radioactive waste that was generated within the state. The Supreme Court said that that was going too far, that the legislature of the United States was in effect commandeering the legislatures of the states, meaning that the federal government was forcing the states to spend their money in something that the federal government wanted them to spend their money, but the state government did not. Other limits imposed on the Commerce Clause exercise of power by the legislature involved guns. In Prince versus the United States, the court ruled that the anti-commandeering doctrine also applied not only to state legislatures' allocation of funds, but also to the use of state agencies, and specifically found that the federal legislature could not mandate that local police conduct criminal background checks on anybody who wanted to buy a weapon. However, Congress does have the power of the purse, as we discussed very early on in this series. And the Supreme Court has ruled that while Congress cannot mandate regulation in certain areas, it can entice the state governments to do certain things by offering them money. And so basically, the Congress can choose to reward states for complying with federal regulations, with federal conditions. So this is so-called conditional spending. The federal government says to the state, if you do this, which we wish you to do, we will give you X amount of money. The Congress, of course, has the power to tax and spend, so that is the exercise of its power to spend money, not the Commerce Clause. So therefore, the Commerce Clause cases do not limit this. In addition to that, the Congress has the authority to promote the general welfare, and that means that it can encourage the states to do certain things that benefit its citizens. And then the 16th Amendment to the Constitution of the United States, which enables the national income tax, also gives the Congress the authority not only to collect those taxes, but also to spend them. So a couple of examples of conditional spending. In the United States, unlike many places in the world, the drinking age, the minimum age for having alcoholic beverages is 21. And the reason for that is that Congress passed included in a federal highway authorization bill, a statement that if the states increase their drinking age, which normally were 18 years, to 21, they would get additional amounts of funding to build highways within their states. And therefore, most states in the United States, in fact, have a 21-year-old drinking age. Another important example is social welfare. There are many systems of welfare benefits for poor people, food benefits for people who cannot afford food, and other kinds of benefits, which exist within the states because the federal government has told them, if you implement systems like this, we will give you, in most cases, billions of dollars in order to implement those programs. Mobility. This is the national highway system of the United States. We are a big nation of over 300 million people and of great geographic extension. And we've spoken about the fact that we have 50 sovereign states and 6 somewhat territorial possessions. So is that compatible with mobility? Well, in fact, it is. The fact is that Americans have an entitlement to travel freely from one state to another, and indeed to establish residency in any state of their choice. The right to travel has been recognized by the Supreme Court of the United States, even though it's actually not expressly in the Constitution. And this is rather curious because the Articles of Confederation, in fact, included a protection, an express protection, of the right to travel. So it is curious that the Founding Fathers did not include it expressly in the Constitution of 1789. But the Supreme Court resolved that it is, in fact, a fundamental right given to any American citizen, and it found multiple bases for it in the Constitution itself. And so, therefore, it has used this right to travel to invalidate mostly state-imposed burdens on that right, even if indirect. Cases. Crandall versus Nevada. A state tax on persons traveling by public transportation was ruled to be unconstitutional. Traveling in public transport should not be subject to the state tax. In Shapiro versus Thompson, a 6-month residency requirement to obtain welfare benefits, also unconstitutional. As I said, the right to travel guarantees your right to temporarily pass through a state, but also your right as an American to move there, to buy a house, to rent a home, and to put your children in school there. And if you're eligible for it, to receive welfare benefits. So the state cannot discriminate against a previously non-resident citizen who chooses to move to that state, the Supreme Court has found. In addition to the express Commerce Clause cases, you also have the so-called dormant Commerce Clause cases. So to explain that, the Commerce Clause can be thought of as an active Commerce Clause, meaning that there has been actual legislation passed by the United States Congress on the basis of the Commerce Clause. And then the dormant one, by definition, means that Congress has not acted to enable legislation or to pass any legislation in that particular area. And yet, the United States Supreme Court and the federal courts more generally use the mere presence of the Commerce Clause to invalidate certain state statutes. It's basically anything that would limit a national common market within the United States. And so this national common market that is being protected by the Supreme Court and by the federal courts through the application of the Dormant Commerce Clause establishes what many Europeans would find perfectly normal in the era of the European Union, that there's free movement of goods, free movement of people throughout the territory of the member states of the European Union. Well, there's something quite similar here in the United States. There's free movement of people, free movement of goods within all the states of the United States. This nation is a common market, the Supreme Court has ruled, in which state lines cannot be made barriers to the free flow of both raw materials and finished goods in response to the economic laws of supply and demand. And so the states are simply not permitted to limit that national common market. The court uses the Dormant Commerce Clause to invalidate protectionist legislation. Normally, we talk about protectionist legislation as being a sovereign power, meaning that it's usually a nation state that exercises it. Well, in the United States, it's the states that try to protect intrastate activity from out-of-state businesses. And so the court has used the Dormant Commerce Clause to invalidate legislation that discriminates against or unduly burdens out-of-state businesses. Interestingly and importantly, this includes not just American businesses from another state, but international firms that try to do business within an American state. And the Supreme Court has increasingly used the Dormant Commerce Clause to invalidate protectionist state legislation in recent years. And this brings to a conclusion our series on the Constitution of the United States. I have attempted to lay out for you the very fundamental, very basic concepts of our Constitution, and we will provide supplementary materials on our Coursera course page for you. But I will continue to lay out the basics of the American government in a future series on the judicial system and on the American adversary system, particularly focusing on the American oral trial. For now, thank you.